Good morning, everyone. I'm Kurt Seuss. Happy to be here today, and we'll be talking about an introduction to cyber insurance. And I'd like to just introduce our panel. And to my immediate left is Kelly Arton. Kelly's an underwriting manager with Liberty Insurance. To her left, Dave Molitano with One Beacon, who manages the cyber book there. And to his left, Jim Whetstone, who manages cyber liability at Hiscox. Megan O'Malley with Besso in London. And to Megan's left is Jennifer Rothstein with Kroll. With that said, my name is Kurt Seuss. I'm with Ironshore. I'll be hosting your morning event this morning, and I want to keep this real informative. This is for you guys. Before we begin, I'd just like to have a kind of a quick poll. How many of you guys are brokers or okay. How many company people? Okay. Attorneys?
There we go.
Okay. Information security or monitoring, et cetera, et cetera. Okay. So we want to keep this, again, this is your session. We want to be real interactive. This helps our panel. Now, of the brokers that are here, how many people have sold a cyber policy? Okay. Just kind of curiosity, how long did it take you to sell on average to a client? Are we talking months? Are we talking 6 months? Are we talking years? Yes to all the above, but an average, it's not, depends. Yeah, and on the size of the client maybe, and banks buy it quick. Community banks, or you're talking larger? Yeah. So maybe we could talk about some of the challenges of selling, a product that no one's had before. Why do you need it now? It was interesting. I saw Larry Poneman not too long ago. Larry made an interesting comment. He's like, people that buy automobiles are real happy. You know, that first year with the new smell of the car and the leather, and they're real happy. And then as time goes by with the services that a car needs, people get less satisfied. With cyber insurance, it's interesting. The longer a company has the product, the happier they are with it. And I think there's a good, demonstration in terms of our expertise in the industry about mitigating risk, managing costs and control, the controls and the costs and expenses. So I think that's some of the things that go into this purchase. So with that said, Dave, let me pose a question. As an underwriter, what are some of the things you look for in an underwriting submission in an application?
That's a good question. When the submission comes in, there's a couple things.
Can you pull the mic,
Yeah.
please?
Hello. So one of the first things I look at is actually, Kurt just mentioned, who's the broker? So as we look at who the broker is, there's a level of expertise on the broker, and you're dealing with a broker who's experienced, you're going to be allowed to ask questions. If you are dealing with a broker that there's not a good relationship or they're new to the product, the mindset might be, the lowest common denominator of price might be who's selling it. So you kind of get an assessment of who you're dealing with from a business perspective. And then when you look at the submission itself, I like to take a holistic view of the risk. So I look through the application, and the normal of where they, where they are and what they do is important. But due to the nature of the internet, location really isn't that important of where their home base is. But do they understand the risk that's inherent in their business model? Because we're at the point now of technology that data is everywhere. It's on our person, it's in our home, and other people have it all the time. We're giving our wallets and our information away. That I have to look at the submission and the company from top down. I mean, it's not just who they are or what they do, but do they understand for the market segment that they're in, whether in the healthcare segment, a retail or consulting firm, that they understand that the different exposures of a data loss are different for each industry, but they take the idea that it's important, it's part of their business plan to keep themselves safe.
I'm throwing things up too. They gave me a list of questions, but I like to. Kelly, let me ask you. So when you're going through an application, and you see that they have a posted privacy policy in the application, and they're doing SSL encryption, and you go on the website and you see that it's in the clear that maybe if they're taking payments and it's not SSL, maybe it's unencrypted, and maybe they don't have a posted privacy policy. How does an underwriter deal with the inconsistencies you may find in an application in dealing with a risk?
Well, sometimes you'd like to go back, if you have a good relationship with a broker, you can go back and say there's a discrepancy between the application and what their website is saying. Is there another place where it may be posted? Maybe you have to try to go in to see if it is SSL. Sometimes, not that the site is automatically. So you have to dig a little deeper, pose questions to your broker, and ask that. So you have to go back, or you might have to dig somewhere else for it, like a
And
little
Jim-
bit deeper into it.
Jim, you want to add, I mean, like, even,
Yeah.
even, years ago, we used to do assessments, right, before binding. Today, no one's doing assessments, so, how do you get your arms around certain things?
I do think that's coming back a little bit. I mean, especially after Target, I do see and hear of more and more carriers, asking for some assistance through third parties to do assessments or doing their own assessments. So I do think that's starting to kind of maybe come back a little bit. The one thing I did want to comment on is something that Dave mentioned about the broker. I mean, I do think, we used to underwrite these, it was, regardless of the account, regardless of the size, we had one underwriting process that we went through. And I think the carriers are getting more sophisticated in understanding that, and the brokers are helping and challenging on this. If it's a smaller account where you have an expectation that they have lower amounts of sensitive data, for example, that you're not going to go through that same kind of detailed underwriting process and the back and forth that you would on a larger account or an account that has more records. So I think, we're trying to do a better job of kind of triaging those accounts up front. And in addition to understanding how the knowledge of the broker, it's also kind of, triaging it to say, look, odds are this is not going to be a big risk. Let's kind of quick quote this, if you will, versus, we need to dig into this one a little bit more. So,
Economies of scale.
yeah.
Yeah.
So I think that's something that's definitely changing, and we're trying to facilitate through our underwriting process.
Kelly, let me ask you, so first party, third party, you want to, let me ask the audience, do you guys understand that there's a different element between the first party liability versus the liability side? Do you want us to get into that aspect, or is that kind of a known kind of thing? Again, I don't know in terms of spectrum of the knowledge of the cyber product. Kelly, why don't you give it a basic
Okay.
overview?
So first party is really the expenses that are out of pocket of an insured or the customer. And the third party is their liability. That's if there was a wrongful act that arose from, say, a liability breach or a network security breach, like there could be a hacking attack or a virus. It also, so that's where it stems from. So your first party on a cyber liability policy, on your first party, you have your breach notification costs, you have your forensic costs and legal expenses. You also have extortion, cyber extortion. There's also public relation costs, your crisis management. And then there's also data restoration and recreation of a system. That would essentially be your first party costs because they're out-of-pocket expenses. And then on third party, besides civil, which would be someone suing because their information was taken, you also have regulatory fines and penalties that could be assessed from a privacy breach. And then there's also media exposure, and as I said, the network security, like virus and hacking.
It's a good overview. And the liability, I'm going to get back to you. What are some of the claims for privacy violations and the causes of action that you're seeing?
Right. So I think most people think of when they're going to get sued, it's a negligence claim that you committed a wrongful act. But there's actually 4 ways we see claims coming in on the liability side. So negligence is one of them. And historically, it's been very difficult for somebody to prove that somebody was negligent. I mean, I'm not a lawyer, but there's elements that you have to prove to prove negligence, and it's been very difficult after these data breaches, especially if there hasn't been any financial harm to me. So probably many of you have received the letters or the new credit cards, or your information has been breached. Nothing's really, none of my money's been stolen. I can't necessarily prove that I've been harmed in any way. They are sharing that the breach occurred. So it would be difficult, and it's been difficult for the attorneys to go sue and say that somebody's been negligent, because you can't show that they've actually been harmed. It's the threat of future harm, that maybe somebody's going to use my Social Security number in the future to do something doesn't meet that test for negligence. So that's certainly been a common one, but it's been a very difficult one for the lawyers to get to stick. The regulatory, as Kelly mentioned, is another one where regulators can then come in and start to investigate you after one of these events, and you'll have some liability associated with that, and potentially some fines and penalties associated with that. Some regulators may ask that you put aside some funds to help compensate the individuals. So again, if I'm one of the ones that had my information breached, rather than me have to get a lawyer and sue that company if I do think I've been harmed, the regulators might set up a fund where I can just process a claim through that facility and get compensated, so I don't have to sue. So that's the regulatory liability that you might have. What we've seen increase because of the difficulties of the negligence claims is more and more companies are negotiating this into their contracts. So you have contractual liability. So if I've got a relationship between with another company and we're going to be sharing sensitive information, there's going to be a clause in my contract where I'm going to say, I'm going to require that you keep it secure, maybe require that you have this insurance, all these things. And if you breach it, you're going to pay for any of my costs. Because ultimately, I'm the one that's going to have to notify my clients that got breached. I don't want to pay for that if you're the one that breached it, my vendor. So I'm going to build that into my contract. So there's the contractual liability. And then there's also statutory where there's laws on the books. I mean, lawyers, they'll dig them up. I mean, the California Medical Information Act, which was passed many, many years ago, didn't really even know the concept of internet at the time, had a provision in there that you couldn't disclose confidential medical information of a resident of California, and if you did, you had a strict liability and you were going to pay, I think it's $1,000, per individual, right? Well, now in today's world, a breach can be 1 million records, and if it's $1,000 that it's strict liability, there's got to be no proof that anybody was harmed. And you can imagine that $1 million or 1 million breach at $1,000, these can be pretty big lawsuits. So there's a lot of laws like that on the books across the country that can also be used and can be liable, or you could be liable under those laws. So those are really the 4 kind of pillars, if you will, of the liability side of the coverage and the exposure.
Okay.
Can I jump
Yeah,
in
chime in,
comment?
Ben.
I think it's interesting. You hear about what Kelly just said about the first-party costs and the third-party costs, and Jim talked about how actually it's been quite difficult to prove negligence, and I think that's part of the reason why we've not seen a lot of third-party claims under these policies. But what we will see and what your insureds will be paying out of and benefiting from the insurance is the first-party costs that Kelly talked about. The second you have a breach, one of the first 2 things you're going to do is find a really good privacy counsel to help you walk through the different laws and the regulations that Jim mentioned to go, okay, you've had a breach. What states do you need to notify? What regulators do you need to notify? What wording do you have to use in your notification letters? And then obviously hiring outside forensics teams who can come in and say, okay, what actually happened in the breach? What information was lost? What information was possibly just put open? What information was stolen? How sensitive was it? How is it protected? And it's those 2 costs that really rack up first and rack up most expensively. So I think when you're talking to clients and looking at risks, you can basically bank on paying out those 2 expenses. But where we've really not seen a lot of activity is on the third-party liability claim.
Yeah, and that leads into the types of losses we're seeing. So Jennifer, with Kroll, what are you seeing as, I guess it depends upon the nature of the class of business and things, but what are you seeing out there in terms of the type of activity that, from the bad actors?
Sure, and I could give a long list of some very cool terms. So I'll pick the top 3 right now, and we can talk afterwards and define them in more detail. But I'll start with phishing attacks. So just who here in the room has heard about phishing? Okay. Who
We're not
knows-
talking fish.
Right. That was my next question. Who knows how it's spelled? Right. PH. Who knows why PH is used? Because that's a common substitute by black hats for the letter F. So there's your trivia for the day. So we're seeing a lot of phishing attacks and spear phishing. And just a quick definition of what that means. It's a fraudulent attempt to acquire personal information by masquerading as a trustworthy site. So it usually goes into the organization via an email. And what we're seeing is that email is prompting the user to enter some credentials. So that could be username or password. So that's one of the attacks that we're working on the most. And just to kind of map that back to some policy language, just based on what Kelly was saying with first-party and third-party costs, where would we fit into a policy form? That loss would probably arise out of data security liability. And it would be either improper or wrongful denial of access to authorized third party to data, unauthorized software, computer code, or virus that enters the systems. So that's where a phishing attack would be found in the policy form, and that would come out as a first party cost. The second activity that we're seeing, ransomware. Who here has heard about ransomware, cyber extortion? So we're working on a lot of events in and around ransomware. And that basically is a form of malware that is used, that basically allows the computer system to just deny access to the user, and they require some kind of payment. So what we're seeing now, that it's not really a lot of money that they're requiring, so we tell our clients, don't pay it, we can usually bypass that code and get the systems up and running. But what we're seeing in the policy forms, a lot of cyber extortion claims come under a sublimit. So that's something to look for, whether it is actually covered in the overall policy provision or there's a sublimit for that. And then we're seeing a lot of botnets. Anyone can take a guess on what a botnet is? I'm sorry?
You're saying bot?
Botnet, yes.
BOT.
BOT, yes.
Basically, maleficent actors take control of large numbers of computers without the knowledge of those computer users, and they typically create herds, which they then market on the black market. So if you want to conduct a spear phishing campaign, you go out and you purchase the use of 1,000 people's computers for 24 hours to send your email or do a denial of service attack or whatever your heart may fancy.
You've taken
Right.
this class before.
Yeah, there's some people who probably should be in the advanced class. But the reason, so the term botnet, it's like a robot. So, you think about a lot of robots that are going through the computer networks, and I think that the benefit that the black hats have when they, get those botnets out in the system is that it expands the damage that can be done. And basically, it's, sort of what you would think of a robot, this automated attack. The three industries that we're seeing, that are affected by these types of attacks are higher ed, professional firms. We're working with a lot of accounting firm clients that are seeing specifically some ransomware attacks, and then the medical institutions. So those are the three industries.
Yeah, I mean, yes, sir.
Just a question for you. If you have a denial of service attack that is resolved by payment of an extortion demand, where do you put that in your schema?
In the policy?
Yeah.
I'm not sure if I'm the right person to answer that, just because I think that's more of a coverage.
Do you ever see that?
Well, we've had some clients that have paid the ransom, and my understanding is when we're working with carriers that are covering these types of events, that actual payment would be covered. But those are just some of the experiences that we've had with carriers. I think everyone handles it differently.
Yeah, some of the rewards coverage is, in addition to the extortion, the carriers will provide rewards cover. I'll give you an example, and it's not just network extortion, it's data extortion. So we were in the middle of an underwriting submission, and I got a call from the broker, hey, hold it, everything's on hold. We got a call from the radiology group, it was a fairly large group, got a call from a shredding contractor. And they said, listen, we found 50 pounds of your radiology records, your x-rays. We want you to move your shredding contract to us. Otherwise, we're going to release them to the public. So what do? They're extorting you for a contract. Do you call they called law enforcement, they called outside counsel, said, okay, get a confidentiality agreement, meet them in public, see what they have. If they have something, we'll go back to the sheriff's office, execute, a search warrant thing. So, that's the kind of thing. We had recently another radiology kind of situation. A hospital got called from a fire department. And the fire department was putting out a fire in a vacant piece of land. And as they put the fire out that was used as a dumping ground, this piece of property, they found x-ray sleeves with the patient's name, date of birth, and the hospital name. Some of the x-ray sleeves had medical diagnosis in them, and about 400 records all over the scattered field. So the fire department picks them all up, calls the general counsel. Now, that was given to a document shredding company who then allegedly had a rogue employee that wanted the silver content in the radiology x-rays and tried to sell them for the silver content in an x-ray, right? So that's the kind of stuff you see. It's just, it's crazy, you know, the extortion. But the last thing personally, I'll tell you, you know, and then I'll post things, you know, but my wife called me and I was going into the office and she said that just checking her email, a Department of Justice seal popped up on her screen. And it said, your computer has been frozen because of a child pornography investigation by FBI. Now, I have contacts with FBI and DOJ and stuff, and I said, that's not the way they operate. But shut every printer off, shut everything off. And she said before she could do that, she couldn't shut her computer off. The webcam turned on, took a picture of her. Then another box popped up and said, you will pay us $350 in a stored value card from CVS or Walmart, otherwise we will not unencrypt your computer. What do you do? So I had a friend of mine that's a forensics guy. It took him 4 months. Probably cheaper to get a new computer at that point. And the more disturbing thing, I run 2 antivirus software. I have a firewall. I have intrusion detection in my own networks. Someone actually got in and actually copied her whole Outlook contacts. It hadn't been exfiltrated, but someone did that, and she had a couple other malware in there that wasn't even picked up by the common malware virus. So we got it all back and going. Well, 6 months after, she starts getting email from her friends saying, are you overseas? We're getting emails that you need money. So whoever got access to that had finally, compromised her credentials. But that's happening. I mean, people use social engineering from Facebook, looking at reconnaissance of companies. Law firms, they don't buy this coverage in mass, but every attorney-client profile is on a website. So if you want to do a phishing attack, I'm the bad guy. You could just give me all the email addresses of an attorney, and hey, I'll send an email saying, what's your suite number? I have a FedEx package. As soon as you respond back, you're done. So, right, so the policies will cover this stuff. Jim, have you seen other claims, unique claims that come to mind?
Yeah, some good examples there. The thing I wanted to point out is that, it's important to understand that your cyber extortion coverage will cover those amounts, but I think more importantly from our experience is that you want to know who's going to help you with that event, because that happens to you personally or your company. What do you do?
Yeah.
We use a company, Control Risks, that is very knowledgeable in this space and knows, look, you don't pay the ransom right away, because if you do, they're just going to attack another part of your network, or just going to say, oh, that was easy, give me more money, and I'm still going to disclose the information. So, you want to know who's going to help you with that event. So it's not just about the policy, and I would say this about these policies in general, not just cyber extortion. It's what access do you get to experts that are going to help you deal with these issues, because there's not a company around that's prepared to, maybe Kroll, because that's what they do, but there's not a company around that's prepared to handle these situations on their own. And so the policy is not just about, how much the check gets written for at the end of the day. It's what services kind of come along with that, and just as important on these cyber extortion events.
Well, I think, just to jump in, the first panel, the claims overview this morning, one of the carriers had mentioned that, this industry and these types of coverages are programs. So the carrier had said that, he was sort of disappointed with some of the insureds that didn't tap into the programs that were available. So I think that carriers are doing a great job in vetting certain experts, putting them on the panel, and then allowing their insureds to access the program. So it's a unique type of insurance as opposed to some of the other policy forms out there that don't have as many experts that are on these panels.
Yeah, not a lot of people are using them. I think a lot of carriers, we have different risk management offerings. We'd like the insureds to use that more, so encourage them, because a lot of it's free. It makes them better risks. Better risks get lower premiums.
But I think there's a big disconnect between, the CFO who's signing the check for the insurance, and maybe the risk manager who is actually talking to the broker and who knows they have it. And if a breach happens, and maybe it's actually the CIO who finds out about the breach, and are they actually talking to all the different people? So, people say this a lot in cyber. It is still a boardroom discussion. It needs to be a boardroom discussion so that all the people, on the board, the C-suite level, directors actually go, oh, we have this insurance in place? Okay, can we all get together and just know, okay, if something happens, this is what we're going to do. And that's when you can start to, I think when insurers will start to actually better utilize all of the front-end services that these carriers are giving now, which are so beneficial to your insurers.
And probably more importantly, I think smaller businesses who don't have the C-level one, that, they don't have the resources to handle this at all. And you saw in the presentation this morning, a small business that has a claim that's gonna cost $360,000, a lot of them go out of business. I forget the statistic that we found, but within 6 months, I think it was over 50% of small businesses that had that type of breach went out of business because they don't have those funds available. So if they're not buying insurance, they're certainly, don't have the funds available. So the insurance is very important for them and those services that are available to them as well.
So Dave, are there minimum requirements that you're looking for from an underwriting perspective of some of the small businesses versus, a larger company?
Yeah, it depends on the class of business, but overall, what we talked about earlier is people who understand their exposure. So if they understand their exposure and economies of scale, as Jim was talking about, is that, do they understand it? So, some very minimum requirements could be a privacy policy that's actually in written form and not just on a website. Consistently, things are consistent from the application through the underwriting process. Laptops encrypted. It's so cheap now to encrypt a laptop that most people should be doing it now. That could be one of the things that, we have a privacy policy, but we don't encrypt our laptops. It's probably more expensive to get an attorney to write the privacy policy for you than it is to encrypt your laptop. The understanding of the risks, some minimum requirements of keeping the data safe, and then as economies of scale, the bigger the company, the more they should have behind their data risk management.
And what kind of red flags would you see from the application or underwriting process?
Tongue-in-cheek responses. I was telling the story earlier. We have an application came in, and the question on the application was, please describe your risk management techniques for data security, and they put, we use the Bible. And I understand the Bible is very good for a lot of people, but it's not going to be good for data security. So to me, that's another, a broker who looks at that wouldn't have let that go through the door, but they just don't get it, or they just don't understand that it's not my a cloud provider, quoted to us stating, I don't see it it's not my role to keep the data safe. My role is to keep my clients' websites up. So those kind of people who don't take it seriously are immediately go to a different pile.
Yeah, I've seen applications where the application asks, have you had any third-party independent security assessments done? And they'll say no. And then further down it said, when was the last information security assessment done? They'll say, October.
Yeah.
I'm like, how can that be? And so I guess everything's fine until the claim occurs. And then, will the carrier deny a claim because there's misrepresentation in the application? I really haven't seen that in the industry per se, but, I'll give you another example. Concern for me is the representations made in an application, are they maintained continuously through the whole year? So you have a person that is concerned and maybe doesn't want to, to represent that they're doing all these great things, run into financial difficulties or whatever, get rid of all their controls, say, theoretically. Just, take the firewall down, get rid of antivirus, it's just too expensive. Is that going to be a covered event? Because at the time that the submission occurred, this was represented to us. And I think us as an industry need to look at that, because this is you could be, and I guess payment card industry, Kelly, we're going to talk about payment card industry, the credit cards, but you could be compliant but not be secure. Yes, sir.
Have any of you had any situations where an insured makes representations in the application regarding PCI DSS compliance, then there's a breach, payment processor inserts a Mandiant or some other company like Mandiant to investigate the vector for the breach, discovers that there was a representation in the app that was inconsistent with reality on PCI DSS compliance, and then you decline based on the findings of Mandiant that are inconsistent with the app rep.
No.
No, but I think,
That seems like a
yeah.
huge
That
issue.
to me is
it's,
not a
it's possible,
misrepresentation.
sure.
But that, to me, is not a misrepresentation. They thought they were compliant at the time.
Yeah.
They went through an
Yeah.
assessment, just because subsequently the card company, have hired another assessor to come in and prove that they weren't.
Well, let's say they
Yeah.
said they had 256-bit encryption, and it's more concrete. They had 128.
That's a different, that's a different story to me. You know, if they've misrepresented to the assessor in the beginning to say they were PCI compliant and they weren't, you know, and then they represented that on the app, you know, that could absolutely lead to a carrier wanting to maybe deny that and you know, but has that happened? It hasn't happened for us, but.
No.
Well, I mean, as soon as there is a breach, you're no longer compliant. So
Right.
if, you know, every carrier could decline a claim based off of that. So
Yeah.
as an insurer, you can't really start to deny claims based off of that. You just have to go, well, again, this is what we were told, it's what you promised us. But as Jim said, I guess there's a different story if you're lying to the assessor from the beginning, but, you know,
I mean, when we work on some of these cases, the report that would actually have those findings would sometimes just be given to counsel. So I don't know if it necessarily would make its way back to the carrier, because, you know, sometimes privilege needs to attach. So if we're working at the direction of counsel, I think the question would be for the carrier, you know, are they requiring to see the report, you know, from a service provider? And you know, I don't know how that factors into the underwriting process, but you know, backing up to when we're looking at applications, sometimes our clients will ask us to help them fill out the applications because they're not really sure if they're compliant, or you know, they're really not sure what the terms are in the application. So I think it depends how the carrier is handling that and how in-depth the carrier wants to investigate.
Yeah.
Well, you bring up a question I wanted to ask. I know technology, but I don't know anything about insurance, all right? So that's why I'm in this room. Do you ever bring to bear technical resources almost to the extent of, say, information security audits or assessment as part of your underwriting process? I mean, you know, let's face it, for almost anyone, information security is not only very difficult, it's practically impossible. I say that from experience in the field. And, you know, you spoke earlier about resources you had. So do you ever bring them to bear up front, or do you wait until you have a claim and then get into these kind of protracted negotiations? I'll just cite as an example, if you read Target's SEC filing, what they have to say about their cyber insurance is that they booked an accounts receivable and they anticipate recovery from insurance, but they didn't go so far as to say it was a sure thing. So just some kind of general questions about how this whole process works.
I'll take the first part.
Sure, you go
The
ahead.
first part is, if I remember the question, is that do we put, you know, third-party assessments as part of the underwriting process? Yes. That's, again, economies of scale, but I think Jim alluded to it also, is that it is important that if a risk is a certain size, that we have to rely sometimes on a third party to take a look at it for help with the underwriting process.
Color around size, when you're talking about size, so what is considered small, you know, in terms of-
That's a good question. You know, if I had a $10 million business, I would consider myself have a good sized business. But in the reality of the world, when you get to someone whose target who's $77 billion, or you know, give or take, to someone who's 10 million would be a small business. So I don't want to speak for other carriers, but usually risks under 25, maybe 35, 40 million, and that ranges for different people, that would be considered a small
But
business.
it's really based on the revenue of the company versus, say, data records or anything like that.
Right.
No,
Yeah.
not-
That's a great question.
Yeah,
That's a great
Yeah,
question.
it's a
Excellent.
combination. Due to technology now, a lot of third-party providers don't need a lot of staff to aggregate data on behalf of, you know, Blue Cross or Blue Shield. They're a third party for an insurance company. So it's really, if they have, we've seen, I you know, keep a list sometimes. I keep a list of, you know, revenue to number of records, and the biggest I've seen is 4 million revenue to 60 million records. So on someone like that, I would say I would want a third-party assessment. They were, for a couple Blue Cross Blue Shields, they handled a lot of payments, but they would also scrub patient data and come up with statistics for the Blue Cross Blue Shield. So, but it was all done with computers, so you didn't really need a lot of people to handle that. So I guess the long answer to your question is it's both, you know, number of records and size.
No,
Yeah.
this
No,
is good,
that's
this is
fine,
good.
yeah.
I mean, typically, the way this is rated is like professional liability. It's typically rated from base rate of revenues as a starting point, and then class of business. So if you're a hospital with a lot of locations versus a hospital with one location, they would be looked at differently. But, the class of business. Then you look at prior acts. So if they've bought this coverage before and you're picking up prior acts, that would add a cost to that premium. And then you look at modifiers, underwriting modifiers, such as their loss control. The better the risk they are, the better the underwriters will rate them from a premium standpoint. So the more they're proactive, the better premium. So that's how this thing's rated. But you make a great statement in terms of where does records count come in? And that would come into the underwriting discretion in terms of the number of records. I mean, a company that's operating with customers in California or Massachusetts may be looked upon differently than a company operating in South Dakota, in terms of attorney generals and things. So that's all plays into the underwriting. So that kind of leads us, Kelly. I don't know, did we answer your question, sir? Kind of?
I
Yeah.
think so. It's a learning process.
Yeah, no, it's for all of us, really, because this continues to evolve, right? So you hear a lot of acronyms, PII, PHI. Kelly, can you kind of elaborate on what that is and why do we look at that? And
Sure. So with PII, it stands for personally identifiable information, and it refers to information that can be used to distinguish an individual. It can be your name, your social security number, a driver's license number, a credit card number, your bank statement, and then it alone or in combination with something else that identifies you, like your address, your date of birth, in combination, that makes it a unique identifier that someone could identify you and therefore use your information. That's what PII essentially is. And then with PHI, that's the protected healthcare information. So it talks about what it includes. It can be an individual's past, present, or future, or physical or mental health condition. It can be the treatment of that person. It can also be past, present, or future payment for your treatment. And then it also includes your identity. It could be your identity, which is, your name, social security number, date of birth, and then it could be released into information. And then you get into HIPAA
right.
with your PHI, which is now a big deal. So I don't know if you want me to go into that further.
Yeah, I mean, there's so many regulatory issues by class of business, and we could have a whole seminar on healthcare and
Yeah.
that and related. But I guess underwriting is an art, right? And it changes. I mean, as I think Reisiger said this morning, last year, unencrypted laptops was a big issue, but we're seeing more hacking. I saw a hospital recently that had 2 claims. They're $2 million into the claims, but they got hit by CryptoLocker, and they got hit by a hacker out of China. At least the IP address stemmed from China, and compromised 400,000 healthcare records. So it could be costly. So, I guess Jennifer, any other things in terms of what you're seeing?
Yeah, I definitely the external hackers pose a threat, but I just wanted to throw out a concept called the malicious insider. So these are the employees within the organization that may have access to data that they will misuse. So, one of the recommendations that we give clients, and I think this is particularly important, for a client that's in the position of being an insured, is to train the employees and also understand which employees have access to what type of data within the organization and why do they have access. It's not always necessary, for example, for somebody in a marketing department to have access to data that should only be available to somebody in the HR department. And I think those types of training programs and explaining to employees, what do you actually need to have access to in the organization to do your job on a regular basis is critical. So we're seeing a lot of cases coming from the disgruntled employee or the employee that was fired whose system access hadn't been turned off properly, or something as simple as the key card that has not been turned off. and then that, former employee comes back into the office and, after hours and steals a whole bunch of data. So in addition to the hackers, also think about the malicious insider.
I would concur on that from a frequency standpoint. We're seeing that a little bit more on our claim side too. Just two quick examples. One was a healthcare company. An employee was double printing medical records. So one copy of the paper record would go to, stay in the office. The second copy would go home to their cousin who was stealing IDs. The second one was a CIO at a tech company was let go on a Friday, and his parting gift was a virus on the company's network. So it's we talk about these, but it's one of those things that you try to get to the next level when you talk to people. That employees, unfortunately, when they go, they're not gentle.
So I guess, Meg, there's a question, yes. Yes.
Towards that, do you find or have you found that, in the hiring process or the employment process that, safeguards such as background checks, drug testing, what have you, is really critical in either reducing losses or preventing them?
Yes.
Yeah.
Criminal steal. Just at a different place.
So Meg, does, in coverage, dishonest acts, there's typically a fraud exclusion in policies with a carve back, but, so this coverage, can you elaborate on how it does or doesn't provide coverage for dishonest ex-employees?
Right, so usually what you're gonna find is in that exclusion that talks about intentional acts, because usually most of these policies are there for an unintentional act of an insider. Obviously, if it's an outsider, it's gonna be intentional. So that's gonna be covered, but when it comes to the insider, it's saying, unintentional. The exclusion on the back of the policy will say, we're not here to cover your fraud, we're not here to cover intentional acts of anyone within the organization or even anybody who had knowledge of intentional malicious acts within the organization. But what they'll do is carve it back to say, but as long as nobody else in the organization knew about this, that there was somebody that was, attempting to do this or could do this down the line, then we will obviously still insure the insured entity as a whole. You're not going to insure that individual, and that individual is likely going to go ahead and be prosecuted in some type of way. But these policies are intended and should be covering, whatever the immediate consequences are for the entity from that. Again, as long as anyone who signed the application or represented the application, and that can be different in policy wordings as to who all that is, whether it's the entire entity or just C-suite level or just the signature. But there should still be coverage for the entity as a whole due to costs that they could incur, whether it is the first party, if it was someone actually literally stole a laptop as they ran out the door. It's going, okay, well, were there individuals on that laptop that we need to notify, or is it going to actually come back as liability costs? But that should and can still be covered under policy.
And then typically, policies exclude regulatory fines and penalties. Jim, can you elaborate in terms of payment card industry fines? I mean, they're really not a regulatory fine, right? They're contractual, but maybe you can give some color difference between contractual versus a regulatory fine and whether the policies cover that?
Absolutely. So, I'll probably get in a little more depth on the payment card industry, the PCI, which several of you are probably familiar with. It is a contractual liability. I think that's a misnomer to a lot of people in the industry that, well, it is very important that you have that first party coverage on your cyber policies. When you have a credit card breach, actually where you're really going to lose the money is on the liability side, because the banks recover the merchant agreement that everybody signs when they want to have credit card swipe machines in their store. Basically requires that you are indemnifying the banks for their losses, be it the fraud, be it the reissuance of cards. That's kind of how that contractual relationship is structured. So any clients that have a credit card exposure really need to make sure that they've got that contractual coverage in their policy on the liability side, because that's where they're going to pay for all those things. It's a liability to them in that contract. So the policies typically will, well, some policies cover the contractual liability, including these merchant agreements. Some don't. Some limit the fines and penalties coverage under the PCI kind of program. They'll supplement that, but then you have to make sure you understand what's a fine and penalty versus what's an assessment. So the assessment is where they have these formulas that the credit card companies have come up with, where they determine what the loss was because of the breach. And so they'll put this formula together and say, well, here's how much was being spent on those cards before the breach, here's how much after, so this much must have been fraud, here's how much it costs to reissue cards. They come up with this assessment value. That's different than them giving you kind of the slap on the hand saying you weren't PCI compliant, so we're gonna fine you because of that or penalize you for that. So understand those differences when you're looking at that coverage as well. To Kurt's point, regulatory coverage, again, fines and penalties generally excluded in a lot of policies. It is carved back in these policies for true regulatory fines and penalties. And you want to make sure that you've got that coverage, not just for those fines and penalties, but also those compensatory amounts I mentioned earlier, where a regulator might say, you know what, give me $5 million, or let's set aside $5 million to compensate those individuals that might have been harmed by this breach. So there's two aspects there. It's the compensatory amounts, but it's also those penalties that they can levy.
Do any of your policies ever cover PCI DSS penalties can be pretty draconian? Those contracts.
That's a good word.
Contracts execution, and they're actually arguably unenforceable because they can't be complied with because some of their provisions are so ridiculous. So I can see scenarios in which you want to perhaps pay counsel to fight back against the payment processors. Is that a coverage that's included in these policies?
A lawyer to fight back.
Well, it's a duty to defend, there's always a duty to
It's a
defend,
duty
right?
to defend
That's a
policy.
third party may be
Yes.
triggered.
Yeah.
Yes.
It'll
Right.
trigger
Is it
Is
coverage.
it in your interest, both as an insured and an insurer, to say, you know what, I'm not gonna pay that fine?
I mean, the bottom line, the way it's gonna play out is the payment card industry has certain vendors that can do the forensics. So when the breach occurs at your little pizza store and the data processor notifies that pizza store, hey, we think there's a credit card compromised with your point of sale. We're bringing in XYZ company that's a forensics investigator on behalf of the card brands. They're gonna come in, they're gonna find something. It could be the security cameras aren't rolling and keeping every 90 days. That's part of payment card industry. Has nothing to do with the network. They'll find something, and then the bottom line is it's gonna be a matter of negotiation and settlement discussions with the insurer's attorneys, outside panel, on behalf of the card brand and negotiate a settlement. And they're gonna hire another forensics firm to refute the card industry forensics investigation. That's the way it plays out.
This is Dave's view and not everyone else's, that it's a business decision. To fight it could cost more than the fine, but we're at the point now, like you said, draconian, and it's almost strict liability. So, part of me said, who's gonna fight this? Who can say, I have done everything you said. I have hit these levels of regulatory compliance. I have a third party. What more could I have done? No one's fought that battle yet.
And what
There
happens?
actually is one company.
Yeah,
sorry,
go ahead, Jim.
Just real quick, there is one company that I'm aware of that is fighting it, and it's
Yes.
a very big company
Tennessee.
that has deep pockets that, is willing to fund fighting back against that.
Is that
But,
Genesco or?
Well, there's also a restaurant in Aspen who,
Yeah, the mom and pop.
brought in, their investigators determined no breach, and they're fighting.
yeah.
Yeah, there's a company in Tennessee that's disputing it. Well, it'll be interesting. I mean, if recently American Express, I think, was in the news about having a potential breach. I don't know much about it. But what happens if the brand is compromised? Will they assess themselves a fine? What if you're a company that paid EMX?
Yeah.
I mean, how do you deal? And there's just so much that is new.
I think something else you have to take into consideration is that what they'll end up doing is after they make that assessment or that fine, if you don't pay it, then the next time you need, you take credit cards, they just withhold those funds.
Yeah.
So they're gonna get their money somehow.
Right.
And you're right, companies are gonna start fighting back, especially because those formulas are just kind of made up to some degree, so.
And the processors have forensics firms that are beholden to.
The brand.
The processor, not to the company that's been breached.
Right.
So, once you let that company inside your four walls, you're already risking a fine.
Right.
And there may be situations in which you may say, no, I'm not gonna allow Andy or whoever
Mhm.
inside. I'm going to hire someone who's beholden to me.
Can't. So the part of that agreement is the
If
brands have they have payment forensics investigators, they call them PFIs, and you can go on the brands, but there's, I think, about 21 payment forensics firms. You have no choice. So, yes, sir.
There's a kind of action by the FTC. It's happened typically to some large companies where they will fine you and then they'll impose a requirement for something like biannual
Right.
security audits for really a long number of years.
Mhm.
Can you write coverage for that type of thing? Or do you typically indemnify, not just the fine, but also the real expense there is the couple million
That's
dollars
covered.
every 2 years?
Kelly, you want to?
Yeah, you know, in regards to, it comes to play that, you know, the FTC, even though they're not legally, you know, there aren't any FTC-like laws or fine that they can assess, that still is essentially covered under the regulatory statute. They can assess, not so much fines and penalties, but they'll assess that you have to do X, Y, Z, or pay into a fund through years
Yeah.
at times, so.
Yeah, Choice Point, Atlanta, my backyard. That was one of the companies years ago, and Federal Trade Commission said, hey, for the next X number of years, you got to do an annual assessment. So FTC doesn't have any statutory ability to impose fines under Title 15. So that's the other thing, is looking at, you know, the industry group, you know, like the banks. They can impose fines and penalties, but you can't indemnify a director and officer. Statutorily, it's prohibited.
Yeah.
Right, so every industry has its own kind of thing, but anyways, great question. Yes, FTC.
have to notify.
FTC would love to have statutory ability to impose fines.
Yeah.
That doesn't seem to stop them.
Well, but the turnaround, again, you can maybe work with the state, you know, so if it's in the state of Massachusetts, this, you know, like the state of Massachusetts could impose under their data security law, under the state laws. So with that, we're wrapping up real quick. I just want to have, we're going to start, Jennifer, just a quick overview, kind of a wrap up in terms of your final thoughts to the
So
audience.
I would say that the malicious insider, so look out for that. The phishing attacks, ransomware. I think everybody probably heard the P.F. Chang event yesterday, so that was a great way to kick off the Net Diligence Conference. I think everybody's eager to find out, you know, exactly what that was about, so we're monitoring that. You know, for the insurance industry, I think that brokers and carriers can certainly help put their insureds in better positions by, you know, encouraging them to take advantage of security risk assessments, doing some tabletop exercises. That was another point that was made earlier this morning. Understand who the decision makers are in the organization that can make some, you know, on-the-spot decisions when there is an event, and figure out, you know, whether that event actually rises to the level of a breach that would require notification. Because as was already mentioned on the panel, the notification costs are really what you're worrying about. The forensic costs typically, which I think is what people find counterintuitive, are usually lower than the cost of actually mailing those letters to victims of any breach.
Megan.
I think going off of that, well, going off a couple things that have been said, I think one thing is, as a broker, make sure that you really are educating your clients on what their insurance package holds for them, whether it is front-end risk management portals in terms of saying, hey, by the way, if your privacy policy isn't up to snuff, here's some companies that you can go work with and hire, and we'll kind of substitute some of the payments to really help you put the right policies and procedures in place. You know, so really work with your clients to make sure they know what they have access to on the front end, not just on the response side of things. And then very much going off of this last discussion on PCI, really look at your wordings and your exclusions and breach of contract when you're dealing with PCI, because that is where I've had my insurers pay out tens of millions because they've got great breach of contract wording from PCI breaches. So make sure you look into that portion of the wording. And then make sure you're talking to your professional services firms. This is something we didn't get to discuss yet, but there's so much crossover between, as Jen noted, accountancy, you know, earlier, lawyers, you know, that's going to be a huge space where we're trying to sell cyber, and lawyers just aren't quite getting it. But there's still so many, I believe there's a lot of costs where a big breach, even a small breach to happen in a law firm that wouldn't be picked up, even on the very, very well-crafted LPO policies, that a cyber policy can tag onto. And in my opinion, don't meld the two together, keep them separate. You really don't want to erode either one of those limits. But those are things to keep thinking about and talking to your clients about, in my opinion.
Jim.
You stole my thunder a little bit on that. Yeah, breach of contract. I mean, you're absolutely right. I mean, anybody that again has payment cards, accepts payment cards, needs to make sure that their cyber policy on the liability side not only includes negligence, those statutory violations and those regulatory, but most importantly, that contractual coverage. And it's not just payment card. Back to another point you made about professional services firms. Any of your clients or any of you that are entering into contracts where there's those confidentiality clauses with respects to the data kind of that's being shared, also need to make sure that you have contractual liability or breach of contract coverage in the liability portion of these policies to make sure that you're actually covered at the end of the day when these events occur. I mean, early on, hardly anybody had any breach of contract coverage, and there were a lot of claims that there was a big question about whether or not the payments would be made by the carriers because it ended up coming through the contractual chain rather than through a negligence claim or whatnot. So don't get stuck in that position with your clients.
Dave?
Please work with your underwriter when we ask additional questions.
Yeah.
Or your wholesale broker.
And I actually think what's really important for insureds and for even your clients as a broker to work with the risk services that are provided by the carrier. That will really help mitigate loss and make your insured a better risk overall.